Hello, Patriots. I'm Lee Watts, and this is Patriot Point, your source for Kentucky news and analysis from a conservative, Christian, and common sense point of view. Well, I hope everybody had a Merry Christmas and are looking forward to a wonderful New Year's celebration. This week on the program, we want to talk about a new law that is being proposed in the Kentucky State Legislature. It is called the Safer Kentucky Act. And isn't that a nice name? Well, they give a lot of things nice names. Let's actually look into this bill. It does a lot of different things. Some of them I like, some of them I don't like, and others I'm like, what in the world are you thinking with this? So let's get into this. First of all, this Safer Kentucky Act is an 18-point plan. Does 18 different things. I've talked about it on the program before, and we're going to hit it again. We need to have bills that are single issue bills, not doing 18 different things. That would, number one, it would make it easier to understand both for the legislator and for we the people. Number two, it would lead to less debate because you're just debating one topic and issue versus 18. Some bills have even more than that. So number three, if you have less of all the debate, it's more clear. It's going to go faster through the system. We can actually get more done. And fourth and finally, you could have a straight up and down vote. Am I for the issue up for a vote or am I against it? Because right now with this Safer Kentucky Act doing 18 different things, you might have something really good, but if you vote for that good thing, it's hand in hand coming with a bad thing. Or the thing could work in reverse. Hey, you didn't vote for this good thing. Why? Well, there was a bad thing attached to it. A classic example of why we need to have single issue bills. So let's look at a few of the things in this Safer Kentucky Act. Again, 18 points. One of them is an auction to buy weapons. Now, hey, you got an auction to buy a gun. Myself, a lot of other patriots going to be real interested in that. However, this auction, you buy the gun, except after you pay for the gun, you don't get the gun. Instead, the gun is immediately transferred to the Kentucky State Police, who will then immediately destroy the gun. I thought maybe I had misunderstood this part of the law, so I looked up the written report on this, and let me just read to you what it says. Auction of confiscated guns allows citizens to bid on confiscated murder weapons with the provision that the guns be destroyed by the Kentucky State Police rather than transferred to the buyer. So that's what it actually says. We're going to have this auction where you pay for the gun, but you don't actually get the gun, and the gun is immediately destroyed by the police. What's the point of that? It makes no sense at all. If you want to donate to the Kentucky State Police, feel free, find an organization, give them some money, and skip this whole facade of an auction to buy guns because that's pointless. There's another point in this bill, which I think this is a very good point. And it says we should put a Kentucky State Police post in Jefferson County, where Louisville is. It's our highest crime rate. It wouldn't have the state police patrolling the streets of Louisville, but it would allow some of the Louisville police officers to go about other duties because they can be backed up by the KSP. Andy Beshear is very against this. First of all, anything Andy Beshear is against, immediately put me down as I'm probably for that. Here's an example of one of those things. He says, well, we shouldn't do this because we have a shortage of state police officers. You know why we have a shortage of state police officers? Because you would not stand by and support them, Andy Beshear, doing all the BLM riots where their organization publicly said they want to, quote, burn Louisville to the ground, and told the police officers to stand down and didn't support them. And surprisingly, we had a bunch of them decide to retire, take early retirement, not enter the system. We get a governor who's actually going to support our people in blue, then you know what? We probably won't have a shortage of police officers. So I think this will be a very good thing, help fight the high crime rates there in our largest city. Now let's talk about one of the other issues, and this is the one that I have a lot of concerns about, and that has to do with wiretapping, saying we're going to allow the Kentucky state government under the police to actually wiretap you, listening to what's going on. And they say, well, we're only going to do this for the criminals, though, for gangs and people doing heinous crimes. A lot of talk was about the Patriot Act when that first came out, saying, well, we're only going to use this against terrorists. But then there was a very broad definition of who is a terrorist. According to official documents from the Department of Homeland Security, if you're a Christian that believes that we ought to be pro-life and secure our borders, then you are officially labeled as a domestic terrorist threat. So this is some of the problems that I have with this, is how it could be broadened. Plus, we already have a law that would allow police organizations to wiretap criminals. So why are we duplicating this and giving this authority to others? This law already exists. It is a federal law. It is U.S. Code Title 18, Part 1, Chapter 119, Section 2518. Let me read what it says. This is the title is the procedure for interception of wire, oral, or electronic communications. This is the wiretapping. Section 3 says, upon such application, where the police fill out an application with the judge to do this, they say the judge may enter an ex parte order, which means they can give the order without the person they're wiretapping knowing about it, because it'd be foolish to let them know about it first. As requested or as modified, authorizing or approving inspection of wire, oral, or electronic communications within the territorial jurisdiction of the court in which the judge is sitting, and outside that jurisdiction, but within the United States in the case of mobile interception device authorized by a federal court within such jurisdiction. So this basically means, and I looked up, this doesn't have to be only federal. This can be state and local level, can go to a judge, say, hey, we want to wiretap this person. You get an approval from the judge, a warrant to already do these things. The judge only has authority in their jurisdiction, which makes perfect sense. So we are duplicating this and allowing more of this authority, which is something that borders on a constitutional problem, to lower levels. I think this is a problem here. New York State already tried to pass this law back in the 60s. New York had allowed a law that allowed for electronic eavesdropping, and it could go on for a few months, and it said, with a reasonable ground to believe that evidence of a crime may be thus obtained. And it allowed for extensions of the wiretapping if it was thought to be in the, quote, public interest. Well, the state of New York passed a wiretapping bill. The United States Supreme Court struck that down in the case of Berger versus New York in 1967. And when you read the Supreme Court reasons why, they say because this is a violation of your Fourth Amendment constitutional rights. Your Fourth Amendment guarantees you the right to privacy against unreasonable searches and seizures. Notice what your Fourth Amendment right says. It says the right of the people, that's you, to be secure in their persons, houses, papers, and effects. This, the court has decided, includes your electronic communications that would be violated through wiretapping. Against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by an oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So it's saying here, we can't just give a wiretap because we think you're maybe a member of a gang or something bad. We have to have a specific crime we think that you are going to be committing, and we are looking for specific evidence, not, well, we're just going to see what comes up. You have to have a person on a specific thing that you are specifically looking for, not just generally listening in to see what we can find out. And that's why this New York, when they tried this law, it got struck down because it violated your Fourth Amendment rights. And I have a concern about this law doing the exact same thing. Notice what one of the United States Supreme Court judges said. He said the right to be left alone is the most cherished of rights, most prized among civilized men. This was a justice of the United States Supreme Court, Louis Banderas, and he is from Kentucky, right there in Louisville. The right to privacy is that right to be left alone. And some people's like, well, I'm just going to give up my rights for just a little while, or maybe they'll only go after the bad guys and it'll have me be more secure. Remember what Benjamin Franklin said about this. He says, those who would give up liberty for security deserve neither liberty nor security. I would add to and kind of alter this statement. It says, those who would give up liberty for security are going to wind up with neither liberty nor security. That's Lee Watts right there. But when we are complacent about our rights, meaning we're not paying attention, we don't think it's such a big deal, when we are complacent about this, allowing infringements on our rights is when we're going to turn around one day and find that these rights are simply gone. Let me give you a quote from Kentucky Senator Rand Paul on this issue.
The Fourth Amendment incorporates this right to privacy. The Fourth Amendment incorporates this right to be left alone. When fear and complacency allow power to accumulate and liberty and privacy to suffer, you might ask, well, maybe I'm willing to give up my freedom for security. Maybe if I just give up a little freedom, I'll be more safe. Well, most of the information that comes on whether you're safe or not comes from people who have secret information that you're not allowed to look at. So you have to trust the people. You have to trust those in our intelligence community that they're being honest with you. That when they tell you how important these programs are and that you must give up your freedoms, you must give up part of the Fourth Amendment, when they tell you this, you have to trust them. The problem is that we're having a great deal of difficulty trusting these people.
Senator Paul went on to say, don't give up your liberty today and expect the government to give it back to you tomorrow. And Senator Paul is quite correct in this. We can't give up some of our Fourth Amendment or other constitutionally protected rights just in exchange for somebody saying, well, it's going to make you more secure, because we're never going to get those liberties back if we give them up. But again, this law does 18 different things. One of the things it talks about is you can have the death penalty if you are convicted of your third violent felony, death penalty for killing a police officer, death penalty if you are convicted for being one of the people, drug dealers dealing with fentanyl. It prevents charitable organizations from furnishing bail of $5,000 or more. Now, that sounds good at first, but then it makes me think about, well, I remember when the Kentucky state government locked up the Christian Kim Davis because she was standing on biblical principles of marriage, and this would have prevented churches from posting bail from her, for her, like charitable organizations. It does so many things. It deals with juvenile court hearings, contraband in detention facilities. It talks about involuntary confinement for people who are declared mentally ill. It talks about homelessness issues. It talks about people who are on the parole board and removing members from this board. It talks about so many different things. Some things I like, some things I don't like, and some things I'm like, what in the world are you thinking? Again, this is a poster example of why you need to have single issue bills. Some good, some bad. Let's divide it up so we can have straight up and down votes. So that's what we have going on this week. Each week, I like to give you information of where I'll be speaking and preaching at for the week to come. So coming on this Friday, December the 29th, I'm going to be at the Election Integrity Conference. That is going to be held over in Hodgenville, and you need to buy tickets for that. On there, you can see the website where you can get tickets. It's cheaper if you order them ahead of time. Then on the 30th, I'm going to be speaking at a pro-life service at the Nelson County Baptist Church, which is on Lutheran Church Road over in Bardstown, and everybody's welcome to that. It's absolutely free. Then on New Year's Eve night, be down in Corbin, Kentucky, preaching at a watch night service at Trinity Baptist Church. It's a wonderful evening with special singing and preaching, and we pray right in to the new year. It's a wonderful event. If you're near any of these places, I'd love for you to be a part of it. So that's what we have going on this week. Starting next week, the Kentucky State Legislature is going to be back in session, and we'll be giving you updates each week on what's going on, who's doing what, and what we as patriots need to do about it. So until next week, I'm Lee Watts for Patriot Point, reminding you that liberty is not a spectator sport.